Good morning, good afternoon, good evening to everyone. Welcome back. I hope you had a good weekend. Welcome back to our virtual executive trade course, to module 6. Our sincere apologies for starting a little bit late today and making you wait anxiously to begin this session. We are having some difficulty in connecting with our main trainer, Mr. Muslim Yilmaz. But should he be able to connect with us, we will have him for this session. But in the meantime, we have another colleague who agreed to step in on a short notice. He's been with that legal affairs division for a number of years. This was his main career before joining our Institute for Training and Technical Cooperation. His name is Mr. Jorge Castro, and he's our chief of our section on course design and training. So he has kindly agreed to take the questions, and I'm sure you'll be able to explore any questions related to dispute settlement. I just wanted to also ask those who have not yet sent us an evaluation form for module 5, which we completed last week, to please send us that feedback. We are very interested. We had 3 elements in that module 5, and we would really like to hear about what was your experience with that module. So for those who have not yet sent us the evaluation, we very much appreciate it if you could send it to us as soon as possible. Now let me introduce this module, which means that you have already received a link to the pre-recorded video on dispute settlement procedures. It was, I think, about 45 minutes video or so, or 30 minutes video. And now today we have a recap and Q&A session, and we've allotted until 4 o'clock for this session. And on Thursday, 24 March, there will be a roundtable discussion on the challenges of the dispute settlement system. And we will have a number of external speakers to join into this discussion. So I invite you also to connect with us on Thursday at 1:30, which is 13:30 Geneva time. So now I think without further ado, I'd like to give the floor to Mr. Jorge Castro. We would take the questions either orally or through the chat. And I hope that we can break the ice quickly, and there will be some questions coming his way. So thank you very much again, Jorge, for being with us and connecting on a short notice. Thank you. The floor is yours.
Thank you, Alicia, and welcome everyone to this session of the course. As you know, dispute settlement is one of the main functions of the WTO in that it helps members resolve their trade disputes through a predictable system of rules and procedures. I'm sure you have plenty of questions. The system is undergoing what we hope it's a transitory situation, as you all well know, because it's not fully functioning as it's been designed to do with the current lack of an appellate review because of the current disagreement among members in the replacement of the appellate body members. But otherwise, the system continues to work and to help members find peaceful resolutions to trade disputes. So I'm open to hearing your questions, either through the chat or by raising your hands as you wish. So I can see one initial question in the chat, in addition to a comment on the presentation of the pre-course video, for which I thank you. So with respect to the question is, how long does a full dispute settlement procedure take on average? And averages maybe are not very indicative here because every dispute is different, and as many of you know, most disputes get solved at a relatively early stage in the proceedings. So a big proportion of disputes get solved through bilateral consultations. And it's only those more complicated disputes that cannot be solved through bilateral consultations. And then they go on to the panel stage. And in some cases, parties are still unable to find a solution, and the disputes go further. So averages don't really tell us the full picture. Of course, even in the consultation stage, parties still have a control of the dispute, so they can decide to prolong the dispute over the 60-day period and to continue engaging in consultations to try to achieve a mutually agreed solution. And as I said, a large proportion of those can actually be solved through consultations. Now, a full dispute that goes from consultations all the way to appellate review can, in the most compressed instance, could take 1 year, but more frequently they take longer than that. Now, as we said, of course, we don't have the appellate review system fully functioning. I see that our colleague Muslim has joined us, so that means that we can both share in addressing these questions that we're receiving right now through the chat option.
Hi Jorge, hi everyone. Sorry for being late. Okay, I am now reading a question. Yes, okay, so somebody commented about binding precedent. I think it's hard to disagree that I don't call it precedent, but past reports may always be relevant to future cases. But the question is really how you treat them. Do you attach binding value to them, or do you use the guidance in them if you find it convincing? There is a difference there. And I think the approach that is in line with the text of the DSU, which I can say is also prevailing these days, is that it's the duty of the panel to interpret the legal provision in front of it. And in doing that, if the panel finds a past finding on the same issue, on the same legal issue convincing, the panel can benefit from that. I think this is a fair description of the status quo as of now. I don't know what Jorge thinks.
Yeah, no, I agree. And if I may add something to that, just in the vein of Alejandro's question, claimants and respondents do rely a lot on these precedents from previous cases. So, Muslim would know more than I, because he's involved in dispute settlement, and I am not, or haven't been for some time now. But when you read any submission by a complainant or a respondent, it's very frequently full of citations to previous cases that support their arguments. So parties do rely to a very great extent to those precedents. Thanks.
True, Jorge. And I think it's more than that. We also see this tendency in academic literature, right? In articles, in books, and so on, that you and I, we have also written to a certain extent. We have to rely on these decisions. I'm currently trying to finish a book that I'm writing in Turkish on safeguard measures. And at the beginning of the book, where I explain the sources of safeguards law in Turkey, you have to, make reference to cases. And I found it, let's put it this way, I paid a lot of attention to explaining the reason why I make very frequent references to the case law of the WTO in that book. Just to say that it is informative. The reason why we have disputes is because, a lot of the provisions in the agreement are not sufficiently clear, at least for some members, and they give rise to disputes. So in that sense, they are informative, but you should also refrain from giving them binding value. That is a delicate balance that one has to observe. I see another question in the chat, the issue of the appellate body, which is a complex and relatively deep issue, but let me perhaps just repeat the status quo. The United States is now not a secret that this one member that has blocked the appointment of new members to the appellate body is the United States. The United States has been voicing certain concerns about the functioning of the appellate body for some years now. And as a result of that, the United States itself decided to take a step further and block the appointment of new members to the appellate body until such time as its systemic concerns are addressed by other WTO members. So this led to the term of the last member of the appellate body expire in December 2020. So since then, we don't have a functioning appellate body. And the consequence of that is that today the panel reports, when they come out and they're circulated, either they are appealed, for which we are now using, or some are using a strange term, which is appealing them into the void. So either they are appealed into the void, which means that their implementation are delayed or is delayed, or the panel report gets adopted. This also happens, like in December last year, there was a dispute brought by the EU against the US, which the US had lost, yet the US agreed to the adoption of that panel report by the DSP. So we have exceptional cases like that, where the parties either mutually decide not to appeal a report, or as in the case of the US, in the case that I mentioned, the defendant, the respondent decides not to appeal and agrees to adoption. But apart from that, mathematically speaking, at least, unfortunately, the tendency so far, the dominant tendency has been appealing panel reports into the void. If you ask me whether there is any solution on the horizon, I would say that my feeling from what is happening and from what I hear from people who are involved in this process is that we are not there yet. We are not there yet, so this will take some more time. How much more time is hard to tell. Another question from Ayşegül. It seems a full dispute procedure takes a considerable time. So Ayşegül is asking whether or not there is any remedies available to complainants because the dispute settlement procedure takes time and the damage caused by the challenged measure continues to affect the industries. Is there anything in the WTO agreement that covers that provides certain remedies for the continued damage during the course of panel proceedings or dispute settlement proceedings? Ayşegül, that is what I understand from that question. The answer is no, because the remedies in dispute settlement are prospective. So there's no mechanism to cover injury that has been caused by the challenged measure before the adoption of the relevant panel or appellate body reports. Because as you know, the DSU says that the task of the panels and the appellate body is to assist the DSP in the resolution of disputes. So the body that actually resolves the disputes is the DSP. The panels and the appellate body, through their reports, they assist the DSP. So the findings and recommendations in a particular report, panel or appellate body report, become international law obligations on the defendant only upon adoption of the report by the DSP. So there's nothing that covers the situation that occurs up to the point of adoption, Ayşegül. Antoine asked the question, a follow-up question, how is the US able to block appointment? All right, the answer to Antoine's question is that the WTO operates on the basis of the so-called consensus principle, which means that decisions such as the selection of new members to the appellate body are made through the consensus of WTO members, which mechanically means that if one member of the WTO disagrees with a proposal, that proposal cannot be adopted. So this is the legal answer to your question, Antoine. Fabian is asking, since cases are becoming more and more complex, is it still reasonable to expect the AB to reach a recommendation within 90 days? Tough question. It really depends, I think, Fabian, on the approach that you take. As you know, the factual issues are not reconsidered on appeal. So that narrows down the scope of the work on appeal. It's limited to legal issues. As you know, also, the appellate body can also use judicial economy, which means that the appellate body can limit its analysis to the claims that it finds to be more central to the case. So if these mechanisms are used, and if you have a tendency to not draft overly long and overly sophisticated reports, then perhaps you can do this. It should be possible. But then if it is not possible, and if, like the US is doing now, if certain members are arguing that reports that come out of the appellate body past the 90-day deadline cannot be considered as appellate body reports, then I think it is also fair to say that members also should look into this. Members also should consider modifying the text to make sure that the text actually complies with the reality of things. Ravi is asking on MPIA, is Mr. Remember the same as, okay, the MPIA is a mechanism that is being proposed by the EU, supported now by, I think, another 25 members of the WTO. As far as I know, it has not yet been applied in a dispute, but we expect it to be applied in the course of this year, because in some ongoing cases, there are indications that because the two sides are supporters of MPIA or members of MPIA, they might use MPIA for appeal purposes in their disputes. In terms of the sort of the operation of the system, it's based on arbitration, which is provided for in Article 25 of the DSU as an alternative dispute settlement mechanism. But when you look at the contents of it and the real sort of functioning of what is being proposed, yes, it is very, very similar to the appellate body system, I have to say, including the selection of the members, including how they handle cases, including the proposed system whereby the WTO Secretariat would also provide technical and secretarial support to the AB. So in all these regards, although it's based on arbitration, which is an alternative mechanism, the substance of it, it resembles very much the current appeal system. Adriana is asking, what do you think about MPIA mechanism as a temporary solution to the appellate body situation? I don't have an idea really about it. It's a proposal. It's an interesting proposal made by the EU. A significant number of WTO members, including some heavyweights in terms of share in world trade, are supporting it now. I think it's a genuine initiative. We will see how it functions in practice. But I also think that given the system provided for, the two-tier system provided for in the DSU, I doubt that anything other than what is in the DSU, including this MPIA proposal, I doubt that it will eliminate the disruption caused by the non-functioning of the appellate body. So that is to say that I see the MPIA proposal as being simply an interim solution to the problem until such time as either the appeal mechanism is back or the WTO members sit together and modify the DSU in a way that would, launch a new system reflecting the reality of today. Adriana, okay. Alejandro, do you think that the entire proposal will incorporate more WTO members? Again, I don't know, Alejandro, but I think it is not unreasonable to say that now that all the WTO members are aware of this, whoever would seriously consider joining it would have joined it by now. So I don't think that there would be an incredible increase of the WTO members that join the MPIA mechanism. Okay, Vilaxe is asking a question to consider the cost to complete a formal case. All right, how much would the average cost be borne by the submitting party? Because as an LDC, my government may not be able to bear the cost. Sky is the limit, Vilaxe. As you know, free market, lawyers, different law firms, different cultures, different fee rates. It's really hard to give a number. But what I should say is that, as you know, hopefully you know, there is this advisory center on WTO law, ACWL, which provides legal support to developing country members of the WTO at reduced rates, which also provides training and so on. So I don't know what is your country, but if it is an LDC, I think your country should definitely consider, if they haven't done so yet, should definitely consider getting in touch with ACWL in case they have a dispute. And I think one thing that I should also add is that a lot of WTO members, particularly developing countries, of course, also use third-party participation as a way to train their people on dispute settlement. This is why sometimes you see a huge gap between the number of disputes that a WTO member joins as a party to the dispute versus as a third party. One main reason behind that imbalance in numbers is that a lot of the countries consider that third-party participation gives them a chance to see the system closely and to train their bureaucrats.
Can I add something?
Please, Jorge.
Just to add something to that question, because I think it's really important, particularly for LDCs or smaller countries. Indeed, as Muslim says, the costs can be elevated, particularly because for many countries, they don't have the internal capacity with staff inside their own ministries to handle a dispute. Some of the bigger countries, of course, and the most experienced countries in dispute settlement in the WTO have either that capacity or are developing that capacity in-house. So very often a small country has to resort to outside legal help. So that's the part of the bad news. The good news, as Muslim says, is that there's many ways to address that issue of costs. And he pointed to one of the most important, which is the existence of this international organization, the Advisory Center for WTO Law, that provides a very high quality legal advice on WTO for developing countries and particularly for LDCs. And so it's a matter of consulting that. But in addition to that, there's other good news with respect to that. The first one is that compared to the situation was many years ago, there's a lot more competition in the market of WTO legal advice. So if you know, just to put an example, I come from Latin America. Before joining the Secretariat, I was aware of the bananas dispute. When the bananas dispute was first brought to the GATT, there were a handful of lawyers in the world that practiced GATT law and that could be hired to accompany a country in a dispute like that to the GATT. Nowadays, that's not the case. Now there's hundreds of lawyers, very highly qualified lawyers in many countries in the world, not just in the United States or Brussels, that are specialized in advising countries in disputes. So that competition has brought the prices considerably down. The other thing is that many countries find other ways to address the issue of costs. For example, pooling together. So in many cases, the concern of bringing a dispute to the WTO is not particular to one country, but there may be several countries in the same case. And again, the bananas case is an example. So several countries joined to bring the case, and of course, they shared the costs. On the other side, in the ACP side, again, several countries were also affected by the dispute in a different manner, and they also pulled together their own resources to get their own legal advice. So there's plenty of ways to address the issue of costs. And ideally, that should not be a barrier to prevent any country from participating in dispute settlement. Thank you.
Thank you, Jorge. And there is also in reality this fact that the companies whose interests are at stake, they also help with the payment of the fees. This is something that we know also from the realities in the field. The next question is from Ayşegül. Again, any possibility of recovering your legal expenses from the other side? No, that doesn't happen in WTO dispute settlement, Ayşegül. Everybody bears their own legal fees and costs. Apart from legal fees for lawyers, there is no cost. The WTO doesn't charge the parties, unlike courts. The WTO doesn't charge parties for its services in resolving the disputes. It's only the lawyers' fees. Fabian has a question. Since the decision on export competition is not an integral part of the covered agreements, could you share your opinion on its concrete legal value? So you are referring to what, Fabian? You're referring to the ministerial decision? Is that a yes? Well, it's hard to give a very quick answer to these questions, but I doubt that it would lack value. I have to go back to the text of the decision to see, but a ministerial decision is a very high-ranking kind of legal instruments, I have to say, in our system. I say I have to see the text of it before answering, because, for instance, the accession protocols of the acceding members have this standard language saying that the protocol is an integral part of the WTO agreement, and it also refers actually to certain paragraphs of the working party reports in the accession process and so on. But it would have a very high value, is the short answer, Fabian. Please, can you explain a little more dispute settlement procedures of WTO? Joachim, yeah, I don't know whether I can go into the details of the whole system, but basically, dispute settlement in the WTO is available to governments that are members of the WTO. Private parties, in principle, cannot be involved in the process. Any measure that is attributable to a WTO member, in other words, any act or omission attributable to a WTO member, can be challenged in the WTO dispute settlement. So this can be a law, a statute, regulation, or a particular action taken by a state agency, for instance. So the scope of the notion of measure is quite broad. There are 5, I think, stages, we can say, of the dispute settlement process: consultations between the parties, then the panel process, then the appeal process, then the implementation process, or 4 or 5 stages. Countries other than the parties to the dispute may also participate in the process as a third party, both in the consultation phase and the panel phase. At the end of the panel phase, a decision is issued. That decision will either be adopted by the political body that administers dispute settlement, which is the dispute settlement body, or it's going to be appealed. In case of appeal, the panel report will be adopted by the DSP together with the appellate body report. So once these reports are adopted, the defendant, the respondent, has to comply with the recommendations and findings in the report, for which the respondent can take a reasonable period of time. At the expiry of that time, if no steps have been taken to comply with the contents of the report, or if the decision is made that the steps taken have not achieved compliance, then either the complainant may seek compensation, or the 2 parties can agree on trade compensation, or the complainant may resort to retaliation against the respondent. But both compensation and retaliation are temporary measures, and they can only be kept in place until such time as the respondent complies with the recommendations and findings in the relevant report. So this is, in a nutshell, I think, the WTO panel or dispute settlement process. Joachim. Andriana is asking, this situation of the appellate body is very concerning, especially to small countries that use the DS mechanism. I fully agree. As a tool, bring legal certainty. Do you see the light at the end of the tunnel? No, I don't. I haven't heard anybody who is seeing the light at the end of the tunnel yet, but we don't know how long the tunnel is. So it might be that it's just around the corner, but we don't see it yet, Adriana. But I fully agree with your assessment that this mechanism is so important to particularly to developing countries. And remember the case that Antigua Barbuda brought against the US and won, about online betting services. A country like Antigua Barbuda, in terms of size, was able to challenge a measure taken by the US and prevail in the dispute, which I think in the absence of a system like the DS system of the WTO would have been next to impossible, you could argue, or would have been difficult. Oliveira is asking, is there any statistic on the number of cases brought by developing members? Yes, there are statistics, Oliveira, and what I recall is that the picture is really balanced. The number or the percentage of cases brought by developing countries against developed and vice versa is very close to one another. So half of the cases one way, the other half is basically the other way. So it's really mixed, which I think is a good sign. And there are also, of course, a lot of cases between developing countries and between developed countries too. Alejandro is asking, do you think the FTA, RTA, DS legal cases in the next future will respect the legal architecture? Will respect the legal architecture of the WTO? Alejandro, are you saying that will imitate or will respect? Because it has to respect anyway, the WTO dispute settlement. If you're asking whether it's going to take after the WTO system or will resemble the WTO system, if you can please clarify the question, what you mean by it, Alejandro. If the question is whether or not they will look like the WTO system, if they will go further. Again, I think it's hard to tell. There are a few FTAs, such as NAFTA, of course, that have a very frequently used dispute settlement system, but I'm not really aware of other FTAs in a similar situation. Turkey has, for instance, as Ayşegül knows, a lot of FTAs. Turkey also has a customs union, and all of these treaties signed by Turkey contain dispute settlement provisions, but I haven't heard even one case in which these dispute settlement mechanisms were used. So I think it is not exaggerated to say that the level of activity, when you look at the overall situation of FTAs and customs unions, the level of activity in the dispute settlement mechanisms there is not comparable to that of the DS system of the WTO. We've had 607 cases so far since 1995 in the WTO, including some really, really high-profile cases. Well, you could say that all cases are high-profile because they are important. So yeah, not at all, Alejandro. I'm waiting for questions.
Muslim and Jorge, if I may, at the beginning of the chat, I saw a comment about the presentation on the pre-recorded video, and the comment that it was helpful, especially the knowledge of the compliance stage. So perhaps while we're waiting for questions, you could maybe outline what happens at that compliance stage to recall us
Sure.
what may be at play.
Sure. Thanks, Alicia, for reminding me this. There is a question already. Did you participate in any case as a lawyer? Yes, I did. Before joining the WTO, I was part of the very, very lengthy consultations process in the dispute between Turkey and Egypt. Ayşegül probably was in high school then, or maybe secondary school, I don't know. So that took a very long time, and it became a panel after I joined the WTO. And I am also proud to announce now that Azevedo has left, I also held consultations together with two other colleagues regarding a complaint that Brazil initiated at the time against Turkey regarding my first ever anti-dumping investigation. So we came to Geneva, we sat on the same table with Mr. Azevedo, who then was #2 at the Brazilian mission. And we somehow managed to convince him that everything that we did was fine, and based on the data that their companies provided, they decided to not pursue the matter any further. So I did participate in these two WTO dispute settlement proceedings at the consultation stage. But in the
I unfortunately haven't had that experience, so I was never an advisor to any dispute. I did serve as a panelist, however, and that was more than 20 years ago. So that probably doesn't count.
Services. You also provided services as a private lawyer. Okay.
That was so far away.
You were smarter than me. I did all this for a government salary. Jorge had a lot of experience, particularly on trade remedies in Latin America before joining the WTO colleagues. So Ayşegül has another question. Could you please further elaborate on the special and special treatment applied for LDCs in the context of this settlement? Ayşegül, there are some provisions. There is actually an article that is entitled Least Developed Countries, if I'm not wrong, in the DSU, and that is Article 24. What I can say is that there are, of course, rules on special and differential treatment of developing countries and least developed countries. But because of the nature of dispute settlement, which is a procedural mechanism, right? It's not substantive like subsidies or agriculture and so on. The nature of the SND provisions are also commensurate with that, if you see what I'm saying. For instance, if the two sides, if the respondent is a developing country, one member of the panel has to be from a developing country, and so on. And if you read Article 24, which has 2 paragraphs about the least developed countries, you can argue that these are, and I think naturally and necessarily, these are provisions that express a certain sort of wish or intention on the part of the drafters, such as, for instance, saying that other members of the WTO should exercise due restraint in considering to bring a case against LDCs and so on. So the answer is yes, there is a whole provision, which is Article 24 of the DSU, but don't expect the nature of these SND provisions in the DSU to be similar to those in other substantive agreements. Okay, with the current COVID, Ravi is asking, COVID-19 situation. A good question, Ravi. I went through a rough journey on this issue in my last case. The answer is yes, the panels can do that. They have the authority to do that under Article 12 of the DSU, and they did do that, including my panel. A number of panels have held virtual meetings in the COVID period. It took some time for panels to, ultimately decide to go that way. In some cases, some parties objected to this idea, but with the expansion of the situation, the sanitary situation, the parties ended up agreeing with this. And so we've had virtual cases, virtual hearings in some disputes. Now, compliance, you said, Alicia. So if I may just repeat the situation about compliance. So let's go to the day on which the panel and or appellate body report is adopted by the DSP. As I said, it is only at the time of adoption by the DSP that the findings and recommendations in those reports become international law obligations for the respondent. That's the first thing to note. So after that, the rule in the DSU is immediate compliance. But often, if not always, this is not possible. So the rules also allow the respondent to seek a reasonable period of time on which the parties can agree, but ultimately this can be decided through arbitration. So if there is disagreement between the parties on what the reasonable period of time for compliance should be, this goes to arbitration and the arbitrator makes a binding decision. The guideline for the arbitrator is that the reasonable period of time should not be more than 15 months, if I'm not wrong, from the date of adoption of the report. So you give the reasonable period of time to the respondent. At the end of the reasonable period of time, there may be two scenarios. One, the respondent has done nothing. This happened in at least one of my cases. In this case, the complainant can move to the next stage, the ultimate stage, which is compensation or retaliation. But if the respondent has taken certain steps towards compliance, then the question becomes, are those steps enough to achieve compliance or not? If the complainant also agrees that by doing whatever it did, the respondent managed to comply with the recommendations and rulings in the report, that is the end of the dispute. If, however, the complainant is of the view that compliance has still not been achieved, then there is a special procedure provided for under Article 21.5 of the agreement of the DSU that allows the complainant to seek a panel's view, which typically is the same panel, as to whether or not compliance has been achieved. That panel report may also be appealed. At the end of that special process, the final judicial word will be said as to whether or not compliance has been achieved. If the decision is that compliance has been achieved, that is the end of the dispute. If the decision is that compliance has not yet been achieved, then the respondent doesn't get any further time for compliance, and it has to, then the complainant can seek compensation or retaliation. Now, compensation is something agreed on between the respondent and the complainant, and it's not money. It sounds like money, it sounds sweet, but it's compensation in terms of a further trade concession, right? So the issue is, for instance, Turkey brought a case against Egypt regarding anti-dumping duties on steel many, many years ago, as I mentioned. Assume that Egypt did not comply, right? Egypt and Turkey could agree on compensation, for instance, in the form of Egypt lowering the customs duties on certain petrochemicals that Turkey also exports to Egypt, right? So Egypt could give a trade concession to Turkey as compensation for purposes of the DSU. But the problem with compensation is that it applies on an MFN basis, which means that other WTO members will also benefit from it, which is why it is not practical and you don't see many cases of compensation. So if compensation is not feasible, which often it is not, then the complainant seeks authorization from the DSP to retaliate against the respondent, right? You need DSP authorization. To do that, what the complainant does is that they propose a document, they send a document to the DSP explaining the situation and describing their proposed retaliation. Most importantly, including the level of retaliation, right, in terms of money. And what happens often in practice is that the respondent objects to the amount proposed by the complainant, in which case the matter is sent to arbitration, is immediately sent to arbitration. This arbitrator, operating under Article 22.6 of the DSU, says the final word on the level of retaliation, right, by the complainant. And once the arbitration proceeding is over, then the report is sent to the DSP, and the DSP authorizes the complainant to retaliate against the respondent at the level determined by the arbitrator. But I should underline again that compensation and retaliation are temporary measures, and they cannot in any way replace full compliance by the respondent of the DSP rulings and recommendations in the dispute. So it only remains in place until such time as genuine compliance is achieved. Thank you, Jorge. Thank you for your contributions. Thanks.
Thank you very much, Jorge, for being with us earlier. Thank you. We appreciate it.
Joachim has questions. Dispute settlement. Joachim, I don't get your question. The dispute settlement procedure, how queries are made? If you can, please elaborate, Joachim. I'm moving to Adriana's question in the meantime. There is a practical matter. Okay, so dispute settlement procedure, how queries are made in the WTO. You mean how information can be obtained, Joachim? About dispute settlement procedures, is that what you mean? Well, you can contact our division, the Legal Affairs Division. You can contact the ITTC, Alicia's division. If it is a delegation of a developing country that seeks advice, there is also, I think there are two experts that are made available by the WTO in the Secretariat building who can provide some advice to those delegations. That is also possible. And if you're more serious about informing yourself on WTO dispute settlement, there is the handbook that the Secretariat published, Handbook on WTO dispute settlement, which is a very useful source, I have to say. Okay, Adriana, there's a practical matter that is happening regarding languages. There, unfortunately for me, because I am a big fan of the French language, there haven't been a lot of disputes in the French language, and I don't want to retire before I work on one. A couple of years ago, there was one, but there were other colleagues available, so they worked on that dispute. Spanish, yes, is an issue, but I seem to feel that we have enough Spanish speakers in our division, at least, but maybe sometimes there is pressure because there is multiple disputes in the Spanish language. But what I can say is that the administration pays attention to this, and often we look for young lawyers who are fluent in the Spanish language. But the thing, of course, is that this is, although it's an important requirement, it's an important need on the part of the Secretariat, it cannot supersede the importance of the substantive knowledge and the experience that is needed for the position. So perhaps sometimes there are problems like that. But apart from that, what I know is that the Secretariat is aware of this, and it's doing its best to make sure that they make a sufficient number of Spanish-speaking lawyers available for these disputes. Can disputes that are filed and adjudicated in RTAs be used as basis for addressing disputes in WTO proceedings and vice versa? Okay, Antoine, this is also a sensitive issue. So what we can say is this. The ESU says that in interpreting the WTO agreement, the panels and the appellate body have to resort to customary rules of interpretation of public international law. Okay? In the very first dispute in the WTO, US gasoline, the appellate body said that those customary rules of interpretation of public international law are found in the Vienna Convention on the Law of Treaties. In particular, it's Article 31. All right, so if you go to Article 31, I think it's paragraph 3C, if I'm not wrong, it provides that one of the instruments that can be used in interpreting a treaty is other rules of international law that are applicable to the dispute, other rules of public international law that are applicable or relevant, other relevant rules of public international law. Now, this has been seen as a gateway through which other international agreements, particularly agreements on the protection of environment, could be used in the interpretation of the WTO agreement. Now, one thing that has to be underlined there is that we are here talking only about using such other treaties as a tool in the interpretation of the WTO. So we cannot possibly talk about amending the WTO agreement through those other agreements. Okay, so that is the scope. Can we use those other treaties, other agreements in interpreting the WTO agreement? The answer is yes, in principle, and the gateway is Article 31 of the Vienna Convention. Now, does that gateway also cover the decisions made by the dispute settlement organs of other RTAs? It's not, those decisions, you could argue, are not rules of public international law. but they are decisions made by other dispute settlement organs in interpreting other agreements. So a WTO panel or the appellate body may find useful looking at those decisions. But I think, fairly easily say that it is unimaginable to think that a WTO panel or the appellate body would base its decision on some interpretation made by a dispute settlement organ of another RTA. That cannot happen. But a WTO panel can very well find useful guidance in those interpretations and at least use them to confirm their own interpretation of the WTO, if you see what I'm saying. Do you have any insight, Oliveira is asking, into how many countries are filing cases in the WTO against their FTA partners? My understanding is that they could resort to resolving them within the FTA framework. Those partners can use either their FTA dispute settlement proceedings and or WTO dispute settlement proceedings. There have been a lot of cases between Canada, Mexico, and the US, which are parties to the FTA. There is a pending case right now brought by the EU against Turkey on pharmaceuticals, and those countries are customs union partners. There was a dispute recently between Qatar and Saudi Arabia. They are also parties to the Gulf Cooperation Council, which is a customs union. So this does happen. But what you should keep in mind from a legal point of view is that the claims are different. The claims that parties submit in those dispute settlement proceedings are different. As far as the WTO agreement is concerned, the claims about alleged violations of the WTO agreement can only be presented by using the WTO dispute settlement system. This is why in the presentation, I must have mentioned this notion of exclusive jurisdiction, which means that alleged violations of the WTO agreement may only be heard and decided by the WTO dispute settlement organs and not by others. And vice versa. In other words, in the context of FTA dispute settlement proceedings, such as NAFTA, for instance, the parties would bring their cases based on alleged violations of the NAFTA agreement and not the WTO agreement. But cross-usage of the decisions in these different fora and so on may happen, as I just explained. The WTO dispute settlement organs may find useful guidance in what these other dispute settlement organs say on similar matters and vice versa. And there have been cases, if I'm not wrong, it also happened in one of my cases where the same matter, for instance, an anti-dumping duty was challenged both at the RTA level and in the WTO dispute settlement system. And there was an objection that, you know, this has been discussed on the other side, it cannot be discussed in the WTO. WTO panels were quick in rejecting these things, these objections. But the fact that the same measure has been challenged, right, in RTA dispute settlement proceedings doesn't stop or doesn't eliminate the jurisdiction of the WTO dispute settlement organs. Board is asking, could DSP review the legality of measures claimed by a member regarding national security? I think there is already a panel report related to this issue. I think there is more than one panel report related to this issue. Ayşegül, I have a long article published in Turkish on this, if you are interested, at Galatasaray Hukuk Fakültesi dergisi. So, national security. The first dispute that discussed this issue in substance was the Ukraine-Russia case, I think dated 2018, if I'm not wrong, right? To put it in a nutshell, this is what happened in that case. The first issue, the big issue was whether or not measures, trade restrictive measures taken for national security purposes could be reviewed by WTO panels, or whether they were self-judging. Right? Russia in that dispute was of the view that these were self-judging measures that the WTO panels could not possibly review. And if I'm not wrong, interestingly, in that dispute, the US as a third party agreed with Russia in this regard. The US also agreed that national security related measures cannot be reviewed by WTO panels. The panel rejected this idea. So as of now, the status quo is such that measures trade measures taken by WTO members on the grounds of national security are not outside the scope of dispute settlement. Now, the next question, of course, is, and let me open the text again, is what is then the scope of this review? The issue was Article 21, B3, which says, nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests, taken in time of war or other emergency in international relations. So the panel basically said that it is for each WTO member to decide what its national security interests are. If you say that my national security interest covers such and such issue, that is your prerogative as a sovereign state, and it cannot be reviewed by a WTO panel. However, what a WTO panel can review are the following. Are you applying this, or are you taking this trade restrictive measure for national security reasons in good faith? Is the action that you are taking, the trade restrictive measure that you're taking, disproportionate compared to your claimed or alleged national security interest? Is there a proportion or not? And finally, the wording of subparagraph 3, which is, has it been taken in time of war or other emergency in international relations? This is also an aspect of such measures that can be reviewed by WTO panels. So these measures, the trade restrictive measures that are taken for the protection of national security, are not entirely outside the scope of the WTO dispute settlement. The panels can review certain aspects of those measures. The one core aspect that cannot be reviewed is the description of the national security interest for each WTO member. I am waiting for further questions, if there are any. Alicia, you are the boss, you decide. We wait for you.
Well, while we are waiting, perhaps there is some thoughts that will come to people. I wondered, because we called this session recap, and of course we hope that participants watched your pre-recorded presentation. If there is any takeaways or important points from what you were trying to convey in that presentation, or for someone to encapsulate the system. I know you walked through this, but I guess since we still have some time and perhaps people are talking, if there is anything that you wanted to address as a way of recap for us to remember, for those who are experts, perhaps they know it. For those who are connecting because they wanted to get more awareness about the system itself, perhaps some general lines of what would be the most important to remember about the system.
With pleasure, Alicia. Two things. Yesterday, I made a presentation to the students at the Royal University of Law and Economics of Cambodia. There, they asked me to look at the dispute settlement or explain dispute settlement from the point, WTO sort of basic principles and dispute settlement from the point of view of businesses. That point of view is very important. And there, what I see in developing countries, including in Turkey, less so maybe in Turkey, but still the case, that companies don't really know enough about the WTO agreement. I once was in Saudi Arabia for a training activity, and a Saudi colleague told me this, jokingly, of course, but probably half jokingly. He said, Mr. Yilmaz, there are two things that people fear in this part of the world. The first is Allah, the second one is the WTO. This is literally what the guy told me. And I said, what do you mean? You know, Allah, I understand, but WTO? He said it's because people just don't know much about it, and they sort of feel at least that it's something very important. It can cause you trouble, but very complex, complicated. And I think that was a very nice description. one should not fear the WTO that much. The rules are very complex. Of course, these are, various areas of specialty. You see people dedicating a lifetime to trade in agriculture, dedicating a lifetime to trade in services, intellectual property. I almost dedicated a lifetime to trade remedies, but then I thought that I was in the wrong direction, so I changed course a bit. I'm dealing with other issues now. So for companies, what can you do? I don't know if some colleagues here are from the private sector. I think the first thing that comes to mind is logical, which is informing them about these things. But I think when you inform companies, particularly when you talk to bosses, these guys are only interested in quick ways to make money, technicalities of rules and so on, bore them very quickly. I think we should adjust the tone or the level of detail accordingly, according to the audience to which we are speaking. These companies should know more about their rights under the WTO agreement. That is my observation. When you have obligations, of course, each WTO agreement contains rights and obligations, right? Your right is my obligation and so on. When it comes to your obligations, the other side will find you quickly, particularly if the other side is a developed country with, significant knowledge and experience in this field. They will find you quickly and remind you of your obligations, and you will end up paying $1 million to some law firm and maybe winning the case or losing and so on. But when it comes to your rights, it is for you to search for your rights, and you do have some rights under the WTO agreements. You do have rights because on a daily basis, trade-related measures are taken by other WTO members, and it is not the bureaucrats in the ministries who are aware of what is happening in the field. It's the companies. So if the companies are not sufficiently informed about WTO issues, particularly if the unions and chambers and so on are not informed, the result is that you lose the chance of, implementing or of seeking some of your rights under the WTO agreement. The corollary of this in the government, in my view, is this. I worked for almost 9 years for the Turkish government before joining the WTO. The problem is that somehow the governments don't really manage to make the decision to have lawyers, a few lawyers, not many, a few lawyers who specialize only in WTO law. That, for some reason, doesn't really happen. You have smart people everywhere. You have good lawyers everywhere. You have good law schools everywhere in this globalized world. Everybody is aware of everything. As Jorge said, you have hundreds of lawyers, working in these law firms. You have WTO law courses in many places in the world. I recently started teaching a regular WTO law course at Bilkent University in Ankara. So you have all this, but somehow the governments don't manage to make that decision and implement that decision to tell two lawyers, look, this is your job, WTO law, start working on it, and you will work on this until your retirement. And these are your benefits and so on, and make sure that they have the right language skills, etc. This, for some reason, doesn't happen in many countries. I know some exceptions, such as, for instance, Brazil, such as Argentina, such as India, for instance, where they have, managed to set up these places in their bureaucracy and make sure that their lawyers stay where they are, and they accumulate this expertise that is needed, and therefore they cut on their costs in terms of participating in WTO disputes. And it is, you can say in a sense, now that national security is really fashionable, I can use the same word. It's also a matter of national security, maybe, right? I don't know. You have your own people in your ministries watching what is happening in the world, in communication with your companies all the time, and assessing the situations that are reported by the companies from a WTO law lens, from a WTO law point of view. That doesn't happen. I think these two aspects are very important. Companies, find a way to inform your companies and make sure that you guys have a sufficient number of lawyers specializing only in WTO law in your ministries. Those are the two things that I find very important. Fabian is asking a question. Do you think suspending the application of the WTO agreements could be considered as a proportional measure under? Fabian, I cannot comment about this because we all know what it is, right? It's about the ongoing situation. Sorry about that. It would be political. Michelle is asking a question. Is the WTO settlement system really effective if one compares the settlement system with the previous settlement system of? Yes, it is definitely, Michelle. And to pick just one aspect of it, as I might have told you or you might have read, the decision-making process was different. In the GATT period, the adoption of the reports was based on positive consensus, which meant that the respondent in the dispute could block the adoption of the report, whereas now it's the exact opposite of it, right? Negative consensus now means that a panel will be established, a panel report will be adopted, and authorization to retaliate at the end will be granted unless there is consensus against it, right? So this means that as long as the representative of the complainant is present at the relevant meeting of the DSP, the decision is going to be made, right? So it's the exact opposite of the GATT period. That is something that makes it, I think, much more effective compared to the GATT period. And today we have an integral dispute settlement system which applies in the same way to all WTO agreements, with the exception of 2 plurilateral agreements, which was again not the case in the GATT period. We have a more legalistic system now with clear deadlines, procedural issues, and so on and so forth. So I think it is fair to conclude that the current system is much more effective compared to the previous GATT dispute settlement system. I don't know the age range, Alicia, of our audience here, but in case we have a lot of youngsters, perhaps we can use the time to talk a little bit about internships and so on, the Young Professionals Program. If you are below the age of, what is it, I think 30, maybe 32 for the Young Professionals Program, I may be wrong, and you're interested in internship in the WTO, the normal internship program, you can access the relevant information through the WTO website. And go to the WTO website, find the link. I don't know what exactly it is, but maybe working for WTO or something. There you will find the link for internships. But then there is this precious, in my view, Young Professionals Program, which is available to countries, to citizens of countries that are not sufficiently represented in the WTO Secretariat. So if you are from a country that doesn't have many people working for the WTO, then you can apply for this Young Professionals Program, which gives you an excellent opportunity to be in the WTO Secretariat for 1 year, to work in one of the divisions. I have now one young professional, for instance, working with me, somebody from Trinidad and Tobago. Last year, I had somebody from Macedonia and so on. So consider these things. These things are important. Thanks, Daniel. Daniel sent the link. These opportunities are important. And otherwise, do not hesitate to apply for jobs in the WTO Secretariat also. Do not make one of 2 mistakes that I find very typical. The first mistake is to think that, no, there must be somebody that they have in mind for this position who is going to hire me. You may well be hired by the WTO. Don't worry about that. It's a transparent, clean system, I have to say. The other mistake is to think that, it's a piece of cake, you know the issues better than anybody else, so you'll just go and get it. That might not also be so easy. So don't hesitate to apply, but make sure that the position that you apply for is one regarding which you have sufficient experience substantively. I'm not talking about the English language skills which are needed for every position, but if you have Spanish and or French, that is an important asset. And don't be frustrated when you apply if you're not shortlisted. That's simply a mathematical problem because there's hundreds of people that apply for these posts, but you may well be shortlisted. And if you are shortlisted, make sure that you study very well about that area. Be ready for a meaningful written exam, which is normally 2.5 hours, 2-3 questions that you have to type. and then again a meaningful interview, an oral exam before a group of experts in the field and HR people to check whether you are insane or not. So it's a serious procedure, but it's doable. You know, the WTO is full of people from different corners of the world, from children of the working class of a lot of countries. You know, it's not you know, people who come from privileged families or whatever. So it's a very transparent, fair, and open system of recruitment. So keep it in mind. And you may very well also contribute to the WTO's work by being in the WTO. And it's an excellent place to work, I have to say that. My last question, Michelle, it doesn't have to be the last question, Michelle, on this very important subject, are WTO decisions binding? Okay, also what happens? Yes, the decisions in the dispute settlement process, Michelle, are binding. Once you lose the case and the DSP adopts the report, you have to comply with the contents of the report, as I said. If you don't, as I just mentioned, the last resort that may be used by the complainant against the respondent is to retaliate. So the dispute settlement decisions are binding, and there are consequences if you don't comply with these rules. What happens if you break the rules? Another WTO member may challenge your measure in the WTO. In other words, they can initiate a case against you. And if you lose, you may be subjected to retaliation. Ayşegül, what are the weaknesses of the DSPs? Yes, Ayşegül, actually, this is a good question. There is this special session of the DSP in which discussions have been taking place, I think, since 2001, yeah, or 2000 even, for the past, 20 years, about improving the dispute settlement understanding. The initial idea was that the negotiations on the DSU would be completed before the other negotiations in the Doha round, but that unfortunately has not happened. And as far as I recall, the DSP special session has not been holding meetings for the past maybe 2 years or so. But in the course of the discussions over the years, a lot of interesting proposals have been made. You know, proposals such as, you know, certain mechanisms about the protection of sensitive confidential information, proposals about the participation of civil society in some cases, the famous amicus curiae briefs, proposals about what else? Many proposals, actually. These are the ones that come to mind quickly. Yeah, third-party participation, enhancing the third party's rights in the process, changing some deadlines in the text, if I'm not wrong. Yeah, there have been actually quite a few proposals, and there is a special document series, Ayşegül, in which you can find either these individual proposals or compilations of these proposals. You can email me if you want to know what these document series are.
While we're waiting for another question, perhaps just to mention, in addition to the YPP program, you would find information about internships and our technical assistance activities on the website. That will be under the topic of technical assistance. And you will also find an annual, biannual plan, TA plan. And we forward invitations to present candidates to the focal points at the missions, and they in turn forward it to the governments. And that's how you found out about the current course in which you've registered and you're following. And also there is a course on dispute settlement. I believe that lasts 2 weeks, that normally is offered in Geneva. I think it lasts 2 weeks, and we will have to see when we have some idea about scheduling for the next 8 to 9 months when exactly that course will be offered. So on that particular subject, watch the space for possible invitations to present candidates for the course if you're interested in this particular topic, but also on any other course or any other specialized topic that will be coming up that you would like to perhaps brush up your knowledge. And the last but not least are the national requests for activities taking place in your countries. And there is a national request form that your government would be filling out to actually seek specific technical assistance on a specific topic. It's good to do it in consultation with your mission in Geneva because they know who to contact. We have regional desk officers who are handling those type of requests, and they could be related to any topic that is of interest to your government. And then the last part is sort of regional courses that we were offering before the pandemic in the regions on specific topics that you may also participate by presenting your candidates. So there is a whole offer of the various courses and also in geographical locations, both national, regional, and those in Geneva global courses that you could perhaps advance your knowledge on this particular topic. So, and we look forward, of course, to seeing you in some other courses as well if you're interested. Yeah, 1 week is the advanced dispute settlement course. It's a 1 week course that we are offering probably towards the end of the year. I believe it will be taking place this year. Are there any other questions, comments, reactions to, or maybe a need for clarification from the presentation that you have watched? If there was any doubt or any questions that may have arose from what you watched in the pre-recorded video. Let's give it a moment to see if there is anybody who would like to ask a question or ask for clarification. Doesn't seem to be the case. I don't think we are missing anybody. I don't see any hands being raised. We've used our time quite well. We still have some time if someone comes back with a question in a moment, but let me mention that on Thursday at 1:30, from 1:30 to 3, we have this roundtable discussion on challenging in the WTO dispute settlement system. And I'd like to invite you to join that session. There will be external speakers. 2 will be from Geneva missions, representatives of the countries in the permanent missions here in Geneva, and 2 will be representatives of the law firms in Geneva, partners in those law firms. So you will hear from people who are working on this, being the representative of the countries in our DS system, as well as those who are perhaps assisting with those disputes from the law firms in Geneva. So I would suspect it will be a very interesting discussion to have that perspective shared with you, and I hope you would have questions or comments and reactions to that roundtable as well. So that will be on Thursday at 1:30 Geneva time. I guess we have accolades to how this session unfolded. I'd like to echo the thanks to Muslim for joining us and for very frank answers to very frank questions, and many of them were challenging, difficult, perhaps sensitive, but I believe you enjoyed that interaction. And also I thank Jorge for joining us in the beginning of the session. And I thank you all for the interactivity in the session and for your patience, for being with us. And I guess if you need to follow up on anything specifically, you would be able to contact Muslim directly.
No problem, exactly. Yes.
Yeah, his email address.
Alicia, thank you once again for organizing this and inviting me to present this issue to the colleagues. I wish to everyone COVID-free and dispute-free days. Thank you.
Thank you, Muslim, for your contribution, and to all of you for being with us today. And we look forward to seeing you on Thursday. Thank you. Have a nice day, nice evening. Bye-bye.